My Lord, my land friend here, Mr. Birivumbuka, labored to persuade you, albeit unsuccessfully, that there is a typo in the indictment, that it was a typing error. To say that the accused persons will be tried at ICD, that it was a typing error. That is the least I would expect from a state attorney of his caliber. With all due respect to my land friend here, my Lord, and I dare say, my Lord, my land friend was extremely dishonest in that submission, extremely dishonest, and I will substantiate. My Lord, if you looked at the record, that statement is in a court order signed by the registrar of the court. Signed by the registrar. It's not up to him as a state attorney to begin impeaching an order of court as being defective. It's not up to him. I don't need to advise him that if indeed that was a typing error, there is a procedure for court to correct its own record. Under the SRIP rule and all these other procedures. He knows. That has never happened, that this matter was ever brought to the attention of the lower court that handled the pre-trial processes, where this record emanates from. Nowhere on record it's indicated that they ever moved the court to correct its record. Never. Secondly, my Lord, my reading of this, there is no typing error. The word, the phrase actually, that you will be tried on the above indictment at the sessions of the International Crimes Division of the High Court. Well structured in perfect English. International Crimes Division of the High Court, boldly stated, with no typing error at all. So it is disingenuous on his part to begin purporting at this stage that there is a typing error on record. Related to that, my Lord, again, the submission he made, that he finds no issues with this honorable court proceeding with the matter which was supposed to be transmitted to the ICD, which was committed to the ICD, because these are committal orders. The committal order is that ICD, that he finds no issue with the file being diverted to Rongo Division. I want to substantiate the submission made by Senior Counsel Martha Karua, the lingering question how the file found its way here. I'm trying to figure out, my Lord, the clerk who got the file from Nakawa Court, with orders, take this to ICD. How did this clerk end up here? How? You are armed with a file from the lower court, the magistrate's court, deliver at the register of ICD. He or she decides to divert the file and bring it here. That speaks volumes about the propriety of the whole process we are trying to interrogate now. Then the last issue, my lord, on that particular matter, Mr. Birivumbuka submitted that these are all the same court. I mean, it's all the same. ICD and these criminal divisions, they are all the same. High court with unlimited jurisdiction. I wouldn't expect that from him again. I wouldn't. That submission, my lord, is neither here nor there. In other words, he's suggesting that actually the land matter can find its way here, or a family cause. There is a family division. There is a land division. My lord, can you handle land matter simply because it's high court or commercial transaction? So the instruments establishing these divisions of the High Court are redundant. They are made in vain, superfluous. For the record, my lord, ICD is a creation of the law. It is the Constitution, the High Court, in bracket, International Crimes Division Practice Direction, 2011. And in the recital there, my lord, you will see, made under Article 133, Clause 1A and B of the Constitution of the Republic of Uganda. The High Court, International Crimes Division Practice Direction 2011, made under Article 133, Clause 1AB of the Constitution of the Republic of Uganda. And in Clause 3, Paragraph 3 of that practice direction, establishment of the division established in 2008 under the War Crimes Act, no, under the International Criminal Act, International Crimes Act rather, as the War Crimes Division, is hereby designated as the International Crimes Division. And my lord, there are rules, specific rules regulating the processes or the procedures before that court, which are totally different from the rules governing this court. And that is the Judicature, in bracket, High Court International Crimes Division Rules of 2016. They are quite elaborate and detailed rules. I don't want to labor you, to waste your time, my lord. And my lord, the peculiarity of this court, the uniqueness of this court, is not only seen in the processes and procedures provided for under the rules, but even the composition of the court. My lord, the practice direction which I have just cited clearly indicates that there are situations where the court can sit as a panel of 3 judges of the High Court. which is not the case with the High Court division here, the High Court Criminal Division. It's not the case. Here it is constant, one judge in all these cases. But International Crimes Division, there are cases where, or rather, there are cases that it may require a panel of 3 judges. Who knows that maybe this could be one of them. He indicated that Mr. Birufumba submitted that the jurisdiction of the other court is limited to war crimes, genocides, crimes against humanity, and terrorism, and so on and so forth. But I would like to draw your attention to paragraph 6 of that particular direction, practice direction. Without prejudice to Article 139 of the Constitution, without prejudice. So this particular instrument is predicated on the provisions of Article 139, which talk about the jurisdiction of this court. That the division shall try any offense relating to genocide, crimes against humanity, war crimes, terrorism, human trafficking, piracy, and any other international crime as may be provided for under the Penal Code Act Cap 120 or Geneva Convention. Any international crime. And when you look at this instrument, the particulars, they are indicating this is a cross-border crime. Kenya, Geneva, Switzerland, wherever. That could have been the reason why the lower court deemed it necessary to refer this matter or to commit it to the ICD, which is well suited to handle those matters, my lord. For your case, my lord, your jurisdiction is restricted here. You can't handle international crimes. You cannot. But for the ICD, they have that mandate to handle international. For the record, by the way, it was established for that particular purpose, cross-border crimes. So I want to conclude, my lord, to wind up my submission on the issue he raised, that they intend to apply for an amendment. That is not a matter to be raised here. No. Actually, my lord, that shouldn't even be considered at all. Their intention. They are giving you a notice that they intended to amend. If they wished to do so, they know what to do. So must this court proceed with an illegality as they wait for the state to effectuate their intention? And even if it was a typo error, a typographical error, would they want to suggest that actually the whole directorate of DPP is that incompetent not to detect that mistake up to this particular moment, that they could not correct it at a lower court? And they want to smuggle in an application here where you do not even have, this court is not clothed with jurisdiction to entertain such matters. Those are matters to be handled at a pre-trial level before the Chief Magistrate Court, if they so wished. So there is no need of citing Section 51 of the TIA here. No need. It's not this court which prepared this indictment. No, it's the lower court. So we reiterate the prayer, my lord, that you be pleased to allow this file to find its appropriate destination, where it was supposed to be dispatched. maybe this was a stopover on its way to ICD. Its itinerary is very clear. From Nakawa, maybe pass here briefly to CID. Let the journey continue up to its final destination. We do so, my Lord.
Particularly by A1 and A2, that this application ought to wait your ruling on the matter that has just been reserved for the 15th. The issues are the same. Yes, my Lord, maybe it can be emphasized a little more by Mr. Karibara, but they have objected to your proceeding with the matter. Is the matter before you? Issues are... Yeah. Okay. Yeah.
Where I say the refusal was made and there is a ruling, the second refusal was made, I don't think it's the application.
Okay. I yield to my learned colleague.